Hello, Council. Today, we're taking a closer look at bifurcation in arbitration, a procedural tool that can either streamline dispute resolution or unintentionally prolong proceedings. When used wisely, it can increase efficiency and reduce cost, but when misapplied, it can lead to delays and fragmented decision-making. So, how do we determine whether bifurcation is the right choice? What is bifurcation? Bifurcation is the process of splitting arbitration into distinct phases, usually separating jurisdiction or liability from damages or remedies. The idea is to resolve a key issue first, potentially avoiding the need for further proceedings. For example, if a tribunal determines early on that it lacks jurisdiction, the case ends without unnecessary arguments on the merits. Similarly, if liability is resolved before discussing damages, the second phase becomes more focused and efficient. However, bifurcation isn't always beneficial. If the issues in the case are too intertwined, splitting them into separate phases may create more complexity instead of reducing it. Why bifurcate? Bifurcation can be a powerful tool when applied in the right context. One of its biggest advantages is efficiency. If an early ruling on jurisdiction or liability eliminates the need for a second phase, arbitration concludes sooner and at a lower cost. Even if both phases proceed, resolving liability first can streamline the damages phase, reducing the need for extensive evidence or expert testimony. Another key advantage is its potential to encourage settlements. Once liability is confirmed, the losing party may be more willing to negotiate rather than proceed to a second hearing. In some cases, this can bring arbitration to a swift and amicable resolution. The risk of bifurcation. While bifurcation has clear benefits, it isn't always the right approach. One of its biggest risks is delay. If the first phase doesn't resolve the dispute, bifurcation can lead to two separate hearings instead of one, ultimately prolonging the process. Cost is another concern. While bifurcation is often viewed as a cost-saving measure, it can have the opposite effect if both phases require significant preparation, hearings, and legal resources. Parties may find themselves paying more, not less, for a drawn-out arbitration. There's also the risk of fragmented decision-making. In some cases, liability and damages are so closely linked that separating them creates contradictory findings or complicate the second phase. When tribunals revisit early ruling, inconsistencies can arise, making the arbitration process more cumbersome. Bifurcation is viewed differently in common law and civil law traditions. In common law jurisdictions, it is seen as a practical case management tool. Courts and arbitrators frequently handle procedural issues first, narrowing the scope of disputes before moving forward. Common law lawyers often prefer bifurcation because it allows them to challenge jurisdiction early or seek a favorable ruling on liability before engaging in a complex damages assessment. In contrast, civil law jurisdictions tend to view arbitration as a continuous process where all issues should be decided together. Splitting the case into phases can be seen as an unnecessary disruption, delaying the tribunal's ability to issue a final award. Many civil law trained practitioners prefer to keep all issues in a single proceeding to ensure a logical and comprehensive resolution. Although arbitration is meant to blend both traditions, procedural tools like bifurcation still lean toward common law approach, especially in international arbitration settings. When to request or oppose bifurcation. Deciding whether to request or oppose bifurcation requires careful analysis. It's most effective when an early ruling could eliminate the case or significantly narrow the scope of the dispute. If liability is highly contested, but damages would be straightforward once liability is determined, Bifurcation can help simplify the process. On the other hand, bifurcation should be avoided if the issues are too interconnected, making it impractical to separate them. It may also be unwise when the tribunal follows civil law traditions, as bifurcation may be met with resistance. Bifurcation can be a valuable tool or procedural misstep, depending on the circumstances. When used strategically, it enhances efficiency and cost-effectiveness. But if applied without careful thought, it can create delays, increase expenses, and complicate decision-making. The key is to assess whether bifurcation will truly streamline the case or simply add another layer of procedure. A strategic approach, one that considers the nature of the dispute, the legal traditions involved, and the potential risks, will ensure the most effective use of this tool. Well, that's it for today. Until next time, sharpen your ADR skills and elevate your practice.